participants for this one, because this is obviously a topic of extremely limited interest, and which is why all of you, being very, very senior professionals, have been selected to be part of this discussion. Binoy sir had set the background of this discussion paper, in that IBBI is proposing to make two significant changes pertaining to governance of IPAs. We are on the forum of a particular IPA, but this particular discussion is about IPAs in general. So this is not specific to any specific IPA. This is, I'm trying to make gradual implementation in the eco structure of the insolvency process. Dealing with various aspects. What comes out and what is extremely appreciated, the regulator is ever in a dynamic improvisation mode. We have not let things to remain static. We have continuously been moving towards improvisations, and that is very characteristic of a dynamic body, which is leading through an extremely important change in the country's economy and trade. So this is basically something which is having to deal with the institutional framework, the ecosystem of insolvency framework in the country. And I have tried to put together the key ingredients of today's discussion in form of a small presentation. So with the permission of everyone, I'll be putting the presentation on screen and take it forward based on the presentation. I think we have a time frame of 2 hours for today's discussion paper, but I'm almost we need as much, because the issues are just barely 2, and well, I think and we have a limited number of participants as well, so I'm hoping that we should be able to round it up sooner than the allotted time. But nevertheless, let's carry it on and see how long do we actually need to complete discussion. So first, basically, to start with a quick understanding of the institutional setting of the insolvency profession in the country. We have the principal regulator in terms of the IBBI, and the IPAs are sort of frontline regulators, because they are the ones who are directly dealing with insolvency professionals. It's not that IBBI is not dealing with insolvency professionals as well, but in terms of the ecosystem, in terms of the structure, IPAs are supposed to be registered, or IPs are supposed to be registered with respective IPAs, and the IPAs in turn are answerable to IBBI. And then, of course, professionals, we have the market participants, which are the stakeholders in the process of insolvency. So that's largely the eco structure, and this was well envisaged by the BLRC as the institutional framework of a sort of regulated self-regulation. It's not entirely self-regulation, because self-regulation then leaves the regulation aspect, but BLRC looked at IPS as a mode of regulated self. There's a regulator as well, in that IBBI has regular intervention in the working of IPS. But the IPAs are sort of statutory regulatory agencies in terms of being self-regulatory bodies, but they come under or come with the powers of a regulator as well. Now, this model that we set in India is not unique to this country, but I would say largely the model is inspired by the UK's institutional framework. In UK as well, they don't have a concept of IBBI. They have the Insolvency Service, which is part of the government. And under the insolvency service, they have the so-called recognized professional bodies, the so-called RPBs, which are exactly at par with the IPAs that we have in India. And under each of the recognized professional bodies, there are different insolvency professionals or practitioners who are members of these different recognized professional bodies. Similar to what we have in India, different professional bodies have set up their own different recognized professional bodies. For example, ICAEW has its own recognized professional body. Then there are, I think, currently there are probably 5 such recognized professional bodies in the UK, which represent different professions. So the Indian ecosystem consists of IPAs as a sort of regulated self-regulation, and they were envisaged as professional SROs. Their members are basically the members of respective professions. For example, in case of ICSI, IIP, The members would largely be company secretaries. And therefore, since ICSI itself consists of a council which is consisting of members, the members of ICSI do have a predominance in the governing councils of ICSI, and therefore might have a role to play in the governing council of IP as well. But given the fact that there is a kind of relevance these bodies have in the working of the ecosystem as well, there is a provision for independent directors as well. We'll talk about that as we proceed. And these IPAs, they primarily do what? They primarily, number one, monitor and monitor the conduct and performance of the members. They also grant authorizations for assignment, which is a statutory requirement under Regulation 7A. And in addition, they do this important job of professional training and development, the so-called, they conduct pre-registration courses as well. And they're also engaged in continuing professional education, which is another very significant role thought by BLRC. And I'm citing from BLRC report when I say that they will induct IPs as their members, develop professional standards and code of ethics under the code, audit the functioning of the members, discipline them, and take actions against them if necessary. That's broadly the role envisaged by the BLRC. And then as we move forward, we are talking about the IPAs as a sort of mini state. When I say mini state, they have a sort of regulatory function as well. So that functions of IP consist of regulatory functions, because it's supposed to set standards and codes as well, or standards of practice as well. They have executive functions because they monitor the working of IPs. They conduct the so-called authorizations for assignments. They also carry out inspections. They gather information about insolvency professionals. And they're also engaged in sort of quasi-judicial function, sort of adjudicative or quasi-judicial function, because they handle grievances, they handle complaints, and they take disciplinary action against members as well. This entirely comes from section 204 of the code, which lists out the various functions of the IPS. And the BLRC report says that all of these functions are with the overarching objective of preventing frivolous behavior and malfeasance in the conduct of IP duties. That's a citation from BLRC report. Section 203 empowers IBBI to make regulations pertaining to governing boards of IPS to achieve the objectives of the. And in terms of that, IBBI has framed the model bylaws and governing board of insolvency professional agencies regulations. When we talk about governance, because this entire discussion paper is on governance and governance standards, question basically is, what is the basic objective of any governance standard? When we talk about any governance standard, the question is largely one of balancing of interests. So we need to understand, is there at all a conflict of interest in the working of, or potential for conflict of interest in the working of IPs as well? So it might be seen that there is a question of public interest versus private interest. Public interest is the interest of trade, profession, industry, credit, etc. that IPs or IBC will try to achieve. There might be a case of private interest, because after all, every insolvency professional has some degree of private initiative, private interest. And to the extent IPS consists of professional members, there might be a question of insolvency professional interest. We can call that private interest. So if at all there is any potential for a conflict between such public interest and private interest, that's where the question of governance standards comes in. And in realization of that necessity for governance standards, IBBI provided that the regulations may specify the setting up of a governing board or governing board of IPA, the minimum number of independent directors, and the number of insolvency professionals who shall be on the governing board of the IPA. Now, I would just maybe give a small international context to this entire discussion as well, because as I mentioned earlier, it's not unique to India that the functioning of IPS has come under examination. And there has been a long trail of discussion in UK as well on trying to improvise the function of the so-called RPBs. Initially, there were, sort of issues about a potential abuse of insolvency industry in sort of academic write-ups. And then Office of Fair Trading in 2001 also identified number of failures. And there were substantial amendments done to the law in 2015. And in 2019 as well, as recent as 2019, the UK Insolvency Service called for further discussion on the question of working of RPBs. And the major objectives of the 2015 amendment basically was to, as you can see on the right hand side, very important objectives. Having a system of regulating insolvency practitioners that secures fair treatment for people affected by their acts, that is the act of insolvency professionals. And then the remaining words are very important. The system is transparent, accountable, proportionate, and ensures consistent outcomes. So very important words. The system should be transparent, it should be accountable, proportionate, and should ensure consistent outcomes. All of these were the so-called objectives of 2015 amendment. And by way of a background, I must say the 2015 amendments in UK law were essentially triggered by lots of complaints coming to the recognized professional bodies about fees charged by insolvency professionals. In India also the charging of fees has been an issue, but in UK it's been even a larger issue, and there were substantial extent of complaints coming on fees, which is what led to the 2015 amendment. Now this was international background, but let's now focus exactly on what IBBI is proposing. As Dr. Binoy mentioned, IBBI has basically picked up two essential issues on the governance structure of IPAs. And the first issue, and I think we can straight get on with the issues. The first issue is requirement of certain qualifications, experience, and other criteria for appointment of directors of IPA. Now, the existing provisions of governance board of IPAs is that the structure must have at least minimum of 7 directors, which would consist of one managing director, so-called CEO. And then there are shareholder directors and independent directors. Shareholder directors basically would be the ones nominated by the respective professional body. For example, in case of ICICI IIP, it would be nominees of ICSI. And then there are independent directors. The independent directors, the number of independent directors should not be less than the number of directors nominated by the shareholder. As Dr. Binoy mentioned, if you have 3 independent directors and 3 nominees, that makes it 3 plus 3. The number of independent directors cannot be less than the number. And the qualifications and attributes for IDs are laid in para 5/6 of the model bylaws. The IDs are nominated from out of a list which is provided by the IPA itself. There are terms of 3 years each. When it comes to reappointment for the second term, the IBBI has to be satisfied about the contribution made by the independent directors in question. And then not more than 1/4 of the total board members not more than 1/4 can be IPs. So number of insolvency practitioners must be limited to not more than 25% of the total strength. Chairperson has to be an independent director. So this is exactly the current situation. Now, what is IBBI's proposal basically is that the question of fit and proper condition. The question of fit and proper condition should be applicable to both the shareholder directors as well as the independent directors. IBBI is wanted to insert a requirement that even the shareholder directors, namely the nominees of the respective shareholding or respective promoting bodies, those nominees must also satisfy the condition of being a fit and proper person. And what exactly is the meaning of fit and proper? That may not be exactly coming very clear from the discussion paper itself, but if you browse through the reference to explanation below regulation 4G of IP regulations, it refers inclusively to 3 conditions. That's an inclusive, not exhaustive list. It's saying the person must be a person of integrity, reputation, and character. The person must have, they must not have any convictions or restraint orders. And the person must demonstrate competence, including financial solvency and net worth. These are the 3 so-called criteria for judging the fitness and propriety of the person. And IBBI is proposing that the nominees of the respective bodies must also have these fit and proper conditions. Additionally, it's also proposing that the person must have qualifications. Now, the list of qualifications is quite broad because we're talking about expertise in finance, law, economics, management, and insolvency. Very, very broad subjects. I think largely when you talk about 5 important disciplines which might have any bearing on insolvency profession, all the 5 principles, all the 5 disciplines have been listed out there. So that's the first issue. And IBBI is asking discussion on whether this condition of being fit and proper and the condition of having prescribed qualifications must be satisfied by both directors as also the the so-called shareholder directors, which are nominated by the body in question. Any contributions on this requirement of why the fit and proper conditions should or should not be applied, or whether the prescribed minimum qualification should be there or should not be there with respect to shareholder nominees? So I would be obliged for any contribution anybody has on this. So the amendment which is being proposed is in sub-regulation 6, and it says the shareholder director shall be an individual who is a person of ability and integrity and who satisfied such other conditions, including experience and qualifications, as decided by the governing board. So after all, it's the governing board which is anyway going to suggest the names, as it's being done even today. But it's linking the qualitative attributes of being a person of ability and integrity and other conditions, including experience and qualifications. There we are still leaving it broad and leaving it, I think, sufficiently permissive as well. But that's the proposed amendment by way of regulation 6. There's a proposed regulation is 6A below regulation 6. The model bylaws and governing board of insolvency professional agencies regulations. Any contribution anybody has on this? I think CGM DR Chaudhary sir has also joined. And any contribution anybody wants to make on this? And Chaudhary sir, any point you would like to provide your inputs, we'll be most happy on that.
Yeah, good evening to all
Very
of
good
you.
evening, sir. Very good.
So, I'm happy to join this. In fact, from the IP division, we originated this. So, any other suggestions also beyond what is there in the discussion paper, that also we can give. And one issue is about the composition of governing board, about the number of insolvency professionals. So, any suggestions on that? Whether you would like the IPs who are there on the governing board, should they be having an AFA? Or you think that they should be having an AFA? Or you feel that the IPs should not be having an AFA? So any other thoughts on that? So that can also forward.
So I'm not sure whether I missed it, but it was not coming very clearly, sir. Maybe because of some voice interruptions. If you could maybe say that once again, sir.
Yeah. So am I audible now? Otherwise, I'll use the microphone.
Much better, sir. Much better.
So any other observations regarding the board of directors, whether they should be insolvency professionals, whether the percentage needs to be modified, or whether the insolvency professional should or should not be having an AFA. So it's generally felt that the IPs should be there on the board so that they can give some perspective. So any thoughts on that?
So any of the participants would like to react to CGM sir has, I think, broadened the agenda quite a bit, so he's even invited suggestions on other issues which anyway we're not aware of when we went into this exercise. But I'm glad to see that he's broadened the agenda quite a bit. But anybody wants to contribute anything on the issue number 1 or any other issue that CGM sir has brought up here?
Yeah, I'm Sanjeev Agrawal. Can I proceed further, sir?
Yes, sir, please.
Okay. One, it's very good that we are discussing something which is very important for the insolvency professionals and the IPA, that is the corporate governance. And members of all the 3 institutes, basically they are the custodians of corporate governance so far as when it comes to governing the stakeholders is concerned. I have a couple of points to my mind. First thing is, we are on the first issue which talks of the appointment or nomination of shareholder directors and appointment or nomination of independent directors. So there are two legs to this issue. One is shareholder director and second one is independent directors. Shareholder directors will of course be appointed by the promoter institute of the IP of the consent and respective IPA. So what I would suggest is to have a broader perspective and to have a well-governed perspective in this regard. The promoter institute should have a nomination committee in the council itself, or the entire council should take a decision that this is the nomination policy when it comes to nomination of members who will be there at the board of the IPA. So it cannot be just that president or vice president or any small group forms, any decides and say that XYZ will be the nominee on the board of the IPA. So ideally, there should be a nomination committee, as we have in the listed companies and banks. That nomination committee may scrutinize all the applications, all the nominations, and then decide on the basis of fit and proper criteria, which again is an issue to be decided now. That what should be the fit and proper criteria. We have the example of insurance companies, we have the example of listed banks, we have the example of listed companies. So in all these cases, we have a nomination committee, and even we have a nomination policy. So in our case also, the institute should have a nomination policy, and if required, a nomination committee also, or the entire council can take that decision. Now, once we have that in place, the policy should also cover who can be appointed or who can be nominated, number one, based on the experience, qualifications, and fit and proper criteria, which we will be discussing. Then apart from that, we have to decide what should be the composition of the board ideally. How many shareholder directors, how many independent directors, how many other directors. So that should also be one of the concerns. When we talk of fit and proper criteria, then we have to see that what should be the fit and proper criteria, like qualifications are there, experience is there. In this case, since the IBBI itself is 4 years old, so we can't have stipulated experience criteria of more than 4 years. So if we have to have IPs on the board, so that is one point. So we have to look at experience which is common to all. Like we can say 3 years experience, because IP, if you want to have experience of 5 years for IP with no Indian IP will be having experience of 5 years, because the IP procedure itself is not 5 years old. So that is one to be taken care of. Two, there should be no conflict of interest. Conflict of interest again is twofold. One, conflict vis-a-vis the institute or the IPA, and conflict vis-a-vis the other stakeholders. And like in case of listed companies, we have pecuniary relationship. Here also we should bring in the concept of pecuniary relationship. That can also be the criteria. Then apart from that, as in the explanation to 4G regulation 4G, it says that there could be certain restrictions in terms of the discipline, in terms of the complaints pending with the concerned nominee. Similarly, there should be no convictions. There should be no defaults as a member of that institute. It should not be a disqualified director. So we can build in and develop a list of parameters which could be considered as benchmarks for to be incorporated as fit and proper criteria. Then expertise is one area where we need to do. Apart from that, in terms of independent directors, my suggestion would be that now IICA, the Indian Institute of Corporate Affairs, has a assessment test for the independent directors. So anybody who is being nominated as independent director, we can at least stipulate that the concerned candidate for the independent director may be a person who has qualified the test. That could be one criteria. Secondly, he should not be a disqualified director in any of the companies, or he should never have been disqualified or convicted in the profession in which he is practicing. Then pecuniary relationship could be one area, and then both independent directors as well as shareholder directors should be appointed for a fixed period, maybe 2 years at least. Minimum period should be 2 years. That could be the thing. And then, if possible, cross memberships could be practiced. Like for example, in case of ICSI IPA, we can have a member who is not a member of ICSI. Like we have nominees in the central councils of all the 3 institutes. A member of ICSI doesn't become a nominee council member in ICSI itself. He can go to ICI or ICWI. So likewise, to avoid conflict of interest, we can also practice this type of stipulation. So these are some of my initial thoughts on the first issue. Thank you.
Thank you very much. I think several issues have been raised, and I would say extremely, at least thought-provoking issues. I'm just trying to start the raise. Number one, he mentioned that Sanjay Agarwalji mentioned that the nomination of shareholder directors must be based on a decision of the nomination committee, as in case of listed entities, and there might be a nomination policy towards that. The advantage of a focused nomination committee is that the committee can then focus on the nomination role, and the committee itself might have, like in case of listed entities, nomination committees might have non-executives as its members so as to bring the needed independence. Additionally, Sanjeevji also mentioned a point about being fit and proper. The existing definition of fit and proper, as I read, is referring to 4G of IP regulations, and there is a bit of abstract inclusive condition referring to integrity, reputation, character, absence of convictions, and competence, including financial solvency and net worth. That's the definition of being fit and proper. There's no elaboration of what exactly would constitute fit and proper, but let's understand that any such condition of being fit and proper has to be abstract and has to be broadly permissive. Even the RBI's fit and proper condition or the SEBI's fit and proper condition, all of these are fairly elaborately, very broadly drafted. They're not like objective tests of being fit and proper. Something like fitness and propriety cannot be subject matter of an objective test. Then he referred to the experience, and he did mention that experience should not be referring to experience as insolvency professional, because then we will not be able to have the background of the existing insolvency practice in India. Then he referred to the conflict of interest and not having a pecuniary interest. I think pecuniary interest may not be relevant here, because in case of listed entities, the interest of the independent director in the company itself is what matters. In case of IPAs, I guess the question of pecuniary interest in the IPA may not arise, but nevertheless, that's an important point to anyway safeguard against. And then he mentioned about the tenure of appointment, and then he mentioned cross memberships of different other IPAs. Like in case of banks as well, director of a bank cannot be director of another bank, so as to avoid the cross directorships. So that these are the significant points that come from Sanjeev Agarwalji's observations. Anyone else who would like to add any further point?
Yes, I am BK Mishra from Mumbai. So,
Sir, go ahead.
first of all, I thanks a lot for making me part of this roundtable conference, which is very important from the point of view of insolvency professional in years to go. So, my point, the question basically, whatever we see that too, the today issue is minimum qualification as well as the self-evaluation of governing board of IPA. As on date, as per secretarial standards, also every board of Section 8 company or any company used to have this self-evaluation. So on that way, I think it is quite necessary also for every company, including IPAs, that they should have a self-evaluation on periodical basis, maybe 1 year or so. Now, second thing, coming on particularly this minimum qualification point, I would see that what is the purpose of IPAs when we see Section 204, that apart from monitoring part, execution part, and quasi-judicial functions, it also has to encompass the interest of the stakeholders, means debtors, creditors, and so all the other stakeholders and society at large. So in my opinion, the minimum qualification of fit and proper, or the qualification which has been envisaged in the Companies Act for independent director, may be quite sufficient. And with the proposed change in IBBI, this qualification that being whatever IPA governing board may feel appropriate, that is quite means wide and which is acceptable also. But basically, what I feel that because as per my perception, this IPAs to develop it in a taking into all experience it into account, it should be little bit participative, open, and so that all other stakeholders, means as on date, like any other our three bodies, ICSI and ICAI and ICMAI, it is like a educative function though, but in my opinion it should broad base so that it should experience that what is happening on the ground level from the IP's point of view, from the perspective of other stakeholders like industrialists. So in that way, my opinion is that whatever we have kept minimum qualification by now is quite appropriate, and fit and proper is the quite whatever elaborated by respected speakers is I think it is quite appropriate. And from the point of view of members, certainly what initially told that 25% of the IPs should be part and not part. That is also okay. That is okay. But from industry side and is from other side of the table, who is the user of all these IPs product must also be embraced in the IPA, and so that anybody who is getting the benefit should also say that yes, it is going on in right perspective, and in the future also we should learn from the experiences whatever we should gain in the process of this IBBI should have. And now coming on the other issue of this for shareholder director and independent director, yes, in case of shareholder directors we may make out this, those qualification. But for independent director, whatever qualification in the Companies Act for independent director has to be there. Like he should be a member of this one, he should pass some exam of the Ministry of Corporate Affairs for such, or he should have otherwise experience to be enrolled therein. These are quite sufficient. These are my points from my side. Thank you.
Thank you very much, sir. I think among the points that you made, this particular point that you just mentioned, which is sounding quite interesting, is that the composition of the board of governing body of the IPA may include at least some participant from the stakeholders as well, market participants as well. I mean, stakeholders definitely include the members of the body, but more importantly, the stakeholders would include the market participants. In this case, let's say the bankers or the trade and industry, which is the direct beneficiary of the insolvency profession. So that's a significant takeaway from the point. Any other feedback on? We will come separately to the self-evaluation bit, but on the qualifications and the experience part, any other contribution anybody has? Okay, so I think let's maybe the four from here.
Just wanted to add.
Yes, sir, please add.
Yeah, so IPA is a kind of front-end regulator. That is why it is proposed that something over and above what is there in the Companies Act should be there. That is why we are proposing this. And the suggestion about market participants, so that is good, I think. So well, we can examine that. So that's a good suggestion. Feel that can be considered actually. So
yes, sir. I think
the board very diverse.
That's a very important feedback, sir. I think the suggestion about having market participants also represented on the board is a very interesting, and it's a novel suggestion because it was not originally envisaged by either BLRC or by the model regulations, but it's a very useful suggestion.
Absolutely. Please go ahead.
Would be they are one of the major stakeholders in the entire process. So could be that one of the independent directors could be from the user side also.
Certainly.
So Vinod, I'm Rajendran here from Chennai. Can I add one small suggestion from my side?
Yes, sir. Please go ahead.
Okay. When we are talking about the composition of the governing board, the qualification and experience came as one of the requirements, one of the criteria. Is there any fixed number of years, let's say, even for an IP to become an insolvency professional, there is a requirement of 10 years and 15 years. To become a governing board member, is there any specific requirement of experience mentioned in the, I couldn't see it in the proposed amendment, the length of the experience or tenure of the experience, be it in any field, like, it could be in a banking perspective or industry, finance, economics, commerce. Somewhere, can we put a minimal experience of, let's say, 5 to 7 years kind of thing?
I think currently there is no such numerical threshold, but if you're suggesting that, we'll take a note of that.
Yeah, in my view, a person with adequate academic qualifications definitely carries some kind of a new perspective, fresh perspective. But always experience, makes a man more versatile, Correct. At least a 5-year threshold would be better, I felt. That's my suggestion. Thank you.
We will take a note of that. I think it just talks about expertise in the respective fields, as I've mentioned in the PPT, in the 5 fields mentioned there.
Yeah.
Probably, in my recollection, there
There
is
is
an
no
age limit as well. There's an upper age limit, probably. Binoy sir, what is the comment?
Currently there is no like number of years experience mentioned. So a kind of feedback would be good to have some kind of because to become an IP, it is 10 years experience in the concerned profession or employment. The same way, in order to control this IPs, govern this IPs profession, it is advisable to have educate years experience at the same or above or the par level of the IPs who are having.
Yeah.
I think that makes sense, because somebody who is going to regulate IPs is less experienced than the persons who is going to regulate sounds a bit counterintuitive. So it's good to have a threshold. I think there is an upper cap age limit as well. Probably 70 is my recollection.
75 actually. It's
75.
75.
Okay.
But it's a good suggestion. We can generally, of course, our independent directors are mostly quite experienced, and independent directors are nominated by IBBI. So we generally take this into account.
Okay.
We can definitely propose.
Okay.
And the important issue here is, as of now, we have, for independent directors, it is totally under control of IBBI. Because
Okay.
we nominate from a list of names
Yeah.
proposed by the IPA. But there is no such, requirement for the shareholder directors. So
Yeah.
issue for discussion is whether we should have such requirement for shareholder directors also.
Kothariji, if I can come in.
Why not?
Yes, sir. Please.
I'm Sanjay Gupta. I'm the former president of the Institute of Cost Accountants of India. First of all, apologize for joining late. I agree with the suggestions. What is the important, because we are being part of the IP for a couple of time. So as I was listening to CGM sir, I think he's very right. If you look at how the IPS are functioning today, what is the criteria of who is a shareholder director? He is a center council member of any of the institution. The qualification is he has to be a CCM of the institute. He automatically is eligible to be a shareholder director. And it's being rightly said, that CCM may be of any of age or any experience or maybe of different perspective altogether. So there is no bar on it whether he can be a shareholder director or not. And what we could make out, I think from IBBI officials and other people can also vote for that. What is generally happening, whatever the institution, there's a lot of noise from the back. Somebody is.
Yeah, some noise disturbances are coming. Yeah. Maybe we can also mute, I think. The mute.
Admin can put on the mute, I think that would be good. Yeah. So what is happening, how the independent directors are being shortlisted and selected. What is happening, whatever the IPs they have, they shortlist the independent directors. And whatever the criteria may be, it depends upon who the people at the helm of the affairs and when they are shortlisting the people. And finally, their names are being sent to IBBI. So IBBI, having a basic criteria, looking at the people. So what is happening, finally the people who are at the helm of the affairs of the IPA, they're also the shareholder director. They're also somewhat, influential in the selection of the independent directors. So ideally, they don't remain independent, to be very honest. So the reason is, ideally, if you really want to appoint an independent directors, it should be never nominated by the IPA. It should be always come from the IBBI or some other governing board. Then only their independence can be touched in the right perspective. Because generally the fear is the people who are appointing them or who are nominating their name, how they can be independent. The moment an IPA is nominating the name of an independent director, so their independence goes then and there itself. So ideally, like in the CAG or somewhere, the auditors are not appointed by the auditee. The auditor's name is given by the CAG. So similar way for any regulatory, being IBBI the regulator, if he says, these are my people, this are the panel. Now we have got an independent directors panel from the Ministry of Corporate Affairs, where there is all people are eligible. So there can be a panel. Out of that, there should be a certain criteria. So it should come on certain merits and some meaningful basis. Another way is, what we could see, there's the shareholder directors also, because the people who are the hem of the affairs in all the, because finally we are run by the three institutions. So only the shareholder directors become who are on the currently, on the present side. So generally we could see, because shareholder directors having a big impact. And to be very honest, all the three IPs, they're not running very independently. To be very honest, that is influenced by their main bodies. Though there is a Section 8 company or a separate entities, but finally, because their principal shareholders are the institutions only. But IPA is altogether a different regulation and different perspective. So there's a lot of pressures on, or you can say a lot of influence of the parent bodies. So somewhat we have to look into that, the shareholder director's role and the independent director should come from outside only. That's my, very fair view.
Thank you, Gupta Sahab. You having been the president of one of the professional institutes, the recommendations become very valuable. In case of independent directors, as CGM sir was saying, the nominations are made by the respective professional bodies, but the ultimate decision is that of IBBI. And we also read in the discussion paper that sometimes IBBI also had to refer back to the respective bodies to change the names of the nominees, perhaps maybe because IBBI was not completely satisfied with the suggested nominations. But you mentioned that instead of the nominating or instead of the IPA itself suggesting the name of independent directors, the nomination should come directly from IBBI. I'm just inquisitive that in case of listed companies, we have the same institution of independent directors, and the names of independent directors may be suggested by the nomination remuneration committee itself. It's not that the independent directors are imposed company by some external body, and yet this institution of independent directors has worked very well, not just in India, but let's say elsewhere in the world as well. So merely the fact that the names are suggested by the IPA or by the promoter body, are we saying that the independence is subject to question?
Yeah, I think to be very honest, I do agree with your viewpoint. With the company, there is a committee which is recommended, but what is happening, you can put in the same perspective. Both are having here, there, what is the promoter is having a stake game. They are in the business or some, whatever way it is. But here what is happening, if you look at the IPAs, every 3 years we have got elections of the institutions. Once an independent director has been appointed, their tenure is from 3 to 5 years minimum. Even that is no clarity whether their tenure is 3 years or 5 years. So once they've been nominated by a particular council or a particular tenure, so the moment the new set of people comes and IPA, what is happening, how it happens. The same IPA is nominating the people in the governance committee, same shareholder directors. They are nominating the people in other committees too. So we have to see it in a different perspective altogether. Because on the practical side, we have seen the concerns and the issue. That's the reason I'm coming out with this. Because once you're a shareholder director and the shareholder director himself are an IPs. So in case anything comes up, so there's no transparency, or you can say there's less of a corporate governance, which we are facing.
You're saying the influence of the existing council of the respective institute could be there in the nomination of independent directors as well. Though, Mr. Gupta, you'll realize that the appointment of independent directors is also for a term of 3 years here. There's a 3-year term and there are 2 terms of Mr. Ganti. I'll just come to you. Yeah. So I think to that extent, there is no continuity or there's no longevity of the tenure beyond years. But the point is fair that after all, it may be the recommendation of the existing council. And well, councils once again consist of members who are for a limited tenure. Mr. Ravi Prakash Ganti, sir, you would want to say something?
Yeah, thank you. 2 points. One, the agenda for today actually does not include independent directors. It is only shareholder directors. Number 2, the regulation draft regulation as proposed basically talks of the governing board of each IPA drawing up the criteria for selection of shareholder directors. It does not talk of the criteria per se. So we are all discussing this, but for what purpose? Because the regulation doesn't say so. Unless it's going to be translated into some form of a guidance note or what, I don't know. I'm just curious as to why we are discussing qualification when it is not part of the proposed regulation.
I think the discussion paper, the background of discussion paper, Mr. Ganti, does have the reference, what I've listed in the PPT is exactly coming from discussion paper. So it does have reference to what qualification. It's left the choice to the governing board of the IPA, but the guidance is there in the discussion. And as regards the independent directors, we about the freedom that CGMs are allowed, that we can even discuss what is not a part of the discussion paper as well. So we all got encouraged, and I think he's actually allowed us to even discuss points which are not a part of the discussion paper altogether. I mean, generally speaking, something which might have a bearing on the working of IPAs. Anything else?
Yeah, in fact, the point which he made about IPs being directors, they have to be shareholder directors. Independent directors are not allowed to be IPs. So his point was whether it should be an IP with an AFA or without an AFA. Valid point, but it was only about shareholder director, not independent director.
Okay, I think to that extent, there's a limit that not more than 25% of the total board strength will be insolvency professionals, whether with or without AFA. AFA probably was not an issue in directorship of IPAs. Probably, I think that's what he mentioned as a side topic. But anyway, I think we'll pick up the issues which are beyond today's discussion paper once we are done with the agenda items of discussion paper itself. So I'm coming to the second aspect of the discussion paper, which is the self-evaluation by the boards of IPS. And I'm sure everyone understands that self-evaluation by boards is also a requirement for listed companies. The boards of directors of all listed companies do a self-evaluation. In addition to that, the independent directors do evaluation of the executive directors, and the executive directors do an evaluation of the independent directors, and all the directors do the evaluation of the chairman. So there are several evaluations that happen in terms of Section 178 and in terms of Schedule 4 of the Companies Act. This is a kind of annual ritual that all companies do. The issue is whether this is a plain ritual or is it serving any useful purpose. Now, one can actually say that mostly the evaluations tend to become a sort of a routine mechanical affair. But if a company wants to honestly let the board do a self-evaluation, to my mind, I think it becomes a sort of self-prospecting, self-realization, self-actualization exercise. When we set into a judgment mode and try to see what are we or where are we in terms of doing validation to a company's board, and I'm sure all of you are very senior people, so must be sitting on boards of several listed companies. It's not exactly just like being an annual ritual giving scores to the respective fellow directors, but becomes a very interesting exercise to probe into what are the areas where there's a further scope for improvisation. So towards that, the Insolvency Bankruptcy Board of India also proposes that boards of IPAs must also go for an annual. It's talking about at least once in a year, kind of self-evaluation. Self-evaluation obviously is not external evaluation; it's evaluation by the board itself, and it's talking about at least the three main issues of self-evaluation, namely board composition and quality. Which obviously will refer back to the previous point that we discussed when we talk about board composition and quality. Number two, the extent of board meetings and procedures. This, of course, has to do with the frequency of board meetings and the procedures followed in board meetings. For example, if the length of notice, was it adequate? Do people come with a prior, agenda notes, which are reasonably detailed? And then it talks about board functions and development. And when I talk about board functions, the major functions of IPS as identified by IBBI are: number one, professional development; number two, compliance; number three, disciplinary matters; number four, services to members; strategy, technology, and human resources. The major functions that the board is responsible for will consist of these seven items of agenda for the board. So in respect of each of these functions, to what extent is the board carrying its functionality? to a desirable level. That's exactly what the board must do at least once in a year. So this is what is proposed by IBBI. If I were to maybe initiate the discussion, to my mind, I think in terms of matter of principle, a self-evaluation is something that all of us need to do. I mean, whether you are in practice or in business or you're in both, you need to and do a self-evaluation of what was your target set for this year, you achieved this year. So a self-evaluation as a mandatory routine is something which is generally always helpful, does not do any damage. It may do a good, but otherwise it would largely be innocuous. So do anybody have any points to add on whether this self-evaluation is going to be a plain ritual or it's going to be a useful exercise? Any contributions, anyone? Maybe I just want to add a small point. Yes, sir. Yes, sir.
Yes, I am again VK Mishra. I add to my previous one note, and as per my perception, whatever functions IBBI has defined for IPA about the regulatory process as a quasi-judicial body or otherwise, I think like any other board, I have a board of the company. Every organization has to have some vision statement, which is the basic statement, or we can say that which is the gist of the objective of the company. One should, all these board should see that based on the vision of the company, what they targets, etc., are fixed based on the vision statement also. So in that case, if we have this self-evaluation or self-actualization system, everybody understand that like self-evaluation doesn't mean that I should do myself. Yes, I should do for my peer group, or as a whole, we should do for all the board or group. So in that case, I think it is certainly it is helpful, because recently for listed companies, it has been envisaged in Companies Act, and why it should not be make a part of this our IPA. So again, I'm coming to the point that since IPA is also part and parcel of the society, like beneficiaries' point of view. So if we keep this one, then certainly every year, periodical basis, 1 year is a period, we should, I think every director or every board member will think that yes, what should be and where we are and what we want to be in future. So in that way, as per my perception, it is an important thing. This is certainly a good thing, has been introduced in a listed company, and we should also embrace it. Thank you.
So Vinod, I have a few points on this topic. Number one, I had an occasion or an opportunity to handle this self-evaluation of the boards in one of the IBC cases where I am the resolution professional now. Thankfully, it was a good corporate. It was a going concern, and we were instrumental in conducting the board meetings, the AGMs, and as part of this exercise, the self-evaluation of the board of directors also we were able to run through the process, and to some extent it was largely helpful to us how this exercise is being done by a company, even though it is under IBC. That corporate data as a going concern and part of a group, we were pushing them, you please go ahead and then do all the things which are required as per the provisions. Even an insolvency professional is mandated to ensure compliances under all applicable laws. So if you apply that kind of a situation to our own IPA, yes, I am for sure that this will definitely improve the transparency, the functioning, the efficiency of the IPA. And in that respect, the items which have been grouped under three major heads, board composition and quality, it's a very relevant item. Board meetings and procedures. In most of the companies, this is one area where a compromise will be made. Either a notice will be sent, a meeting is going to happen on such and such date, but agenda items doesn't reach in time for the independent directors or other directors to read. So in this area, I think the participants should be getting a good opportunity to go through the papers, background materials, and give a contribution, a good contribution to the discussion. The third point, the board functions and development. This is where, in this point, I have a small little bit of a suggestion. It is not a regular corporate entity doing some manufacturing or selling of the services. Here it's a regulatory body or a regulated, self-regulated regulator kind of a thing. I think this is the definition somewhere I saw. Regulated self-regulation for the IPA. So here the heads up items are integrity of accounting and financial reporting. Do I understand it correctly that the integrity of accounting and financial reporting is for the IPA, right? We are talking about the IPA's financial reporting. Promoting transparency is fine, good governance is excellent, and open channels of communication with the top management is fine. Achieving the objectives, if there could be a metrics of where do we stand on the achieving the objectives, that could be better, I thought. That's my suggestion, Mr. Vinod.
Vinodji, hello.
Yes, sir.
Vinodji, I'm extremely sorry. I actually tried to raise my hand, but it so happened that I had some issue with my audio. So even if I was trying to kind of speak up, so in fact, I could not even share my suggestions for the previous, the first topic. So if you allow me, I'll just take a minute and a half, so that I can just put forth what I wanted to say. So and also I heard Mr. Chaudhary actually specifically asking a particular point, which was with regard to the AFAs. AFAs, for the IPs who are on the board. Now, from my perspective, I think from my perspective, it's important that AFAs would need to be there with them, because whosoever continues to be on the board cannot be deprived of that opportunity to not be able to practice in case he is, unless until there is a conflict or any such situation arises where he can recuse himself. Otherwise, it's very important to have 25% of IPs representing in the board, so they probably put up the grounds up feedback. So that's actually important. So that's my answer, that AFA has to be there. Second thing was the qualification and the experience. Whatever is being discussed about the shareholder director or the independent director, to me, it should apply to both, for the simple reason that people who are actually at the helm of affairs, who are forming or composing the entire board, they all need to be people with enough review, pedigree, experience, qualification. So I think it may not really kind of make sense that one category should have restrictions with regard to the qualification experience, and the other one will be just a nomination respective of wherever they come from. So to maintain that consistency, I think that should apply to both. Third important point, and I second Mr. Sanjay Gupta here, is as far as the list of IDs is concerned, it in any case, since it's given by the IP himself, so the list by default becomes a very restrictive play as far as IBBI is concerned to choose the IDs from. So if we really are looking at the independence of the so-called independent directors, I think it really makes sense to have it from, from beyond the list, or for that matter, even that entire concept of, provision of a list by the IP should not even be there. I mean, that's my take, I would say. So these were the 3 points. A very small, quick query to Dr. Benoy. Is the board of the Section 8 company is same as the governing board? Because I didn't find that in the paper anywhere. Are we saying that these are two different things, or it's the same? Just a small query, if I have the answer for that. Dr. Benoy, you're there? I don't know.
Or anyone from my IP here can maybe clarify.
Yeah.
I guess we're talking about the same thing. Yes.
It's same thing. I'm not from IIP, but it is same thing.
Okay, because here it says independent directors and shareholder directors probably will be equal, but it will be the chairperson will be the independent director, right? Where in a normal board, you have a chairman who may or may not be. So I just thought are these two different of the same body, but that's okay. So I've given my 3 suggestions, but that actually linked to the first topic. For the second, I'm more a patient listener, so I'm good with that. Thank you.
Thank you very much, Mr. Ahuja. Mr. Rajendran had made a very significant comment, and I think this is having to do with the draft of the regulation. The proposed text of the regulation, the clause of sub-regulation 14 as appears in the draft, is when it talks about governing board functions and development covering aspects such as And it talks about integrity of accounting, financial reporting, promoting transparency, good governing, open channels of communication with top management. That seems like relevant to a normal listed entity. In context of IPAs, I think more importantly would have been the basic functions of an IPA itself, which is, as I've underlined on the PPT, professional development, compliance, disciplinary matters, services to members, strategy, technology, and human resources, rather than the routine stuff such as accuracy of reporting and all. Those are anyway, I mean, the functions of any board, but in the context of IPAs, the more important point is these board functions, which are specifically the functions of an IPA. So I think maybe to this extent, the draft regulations might need a bit of relook. Also, just an added point before somebody else wants to maybe also comment on that is that these so-called self-evaluations, they are done by the IPA board, but are they like published? Are they proposed to be published or made public anyway? I would just like to add that there are similar reviews done by UK Insolvency Service as well. And this is an annual publication called Annual Review of Insolvency Practitioner Regulation. It's one single report for all the RPBs. RPBs in UK are same as IPs in India. And this is published by Insolvency Service itself. So somewhat similar to IBBI publishing the review of all the IPAs. And maybe that review might include the so-called self-evaluations as well. Because the self-evaluation remains a self-statement also. It remains kind of intrinsic and internal statement to the board itself. Then maybe that might be affecting the accountability. Whereas if it goes out as a part of a public statement, then the seriousness may be bit more. Any other contribution to this thought of self-evaluation by the governing boards? Otherwise, as Mr. Chaudhary gave us permission, so I think maybe there are some other issues of corporate governance of IPAs that I might just like to flag. They were not exactly a part of today's agenda, but I just picked up a couple of points which are meaning gaining from experience of similar statutory regulatory agencies, so-called SRAs, which have been there in lots of other spectrums, such as SEBI or Competition Commission of India or IRD, etc. There are some issues which have been flagged by courts also. So I would just like to very quickly mention those. But should there be any other point on the last two agenda items? Okay, so basically any such body such as IPA primarily has three functions. It has a legislative function, it has an executive function, it has a judicial function. In context of IPAs, legislative function will be making of regulations, making of standards or making of regulation. That's a legislative function. Executive function, for example, granting of an AFA is an executive function. Exempting, investigating, or prosecuting, that is launching a prosecution, that's also an executive function. Then comes the very important function, which is adjudicating and penalizing. This is called a quasi-judicial function, because this is obviously affecting the concerned person as is undergoing an action. So the settled position, which is coming from several rulings of Supreme Court, there's a very important ruling of Supreme Court in the case of Clariant International versus SEBI, which is talking about a doctrine of separation of powers. And what it basically says is that normally speaking, each of these three functions should be mutually segregated. But most importantly, the judicial function, which is the adjudication and penalizing function, must always be an independent function. It should be independent of the last two buckets. And this point also was stressed by the Financial Sector Legislative Reforms Commission, headed by Justice Balkrishna, which also made very important recommendations towards this. And going of the Financial Sector Legislative Reforms Commission, it talked about also certain safeguards to be followed in terms of issuance of disciplinary proceedings. And it talked about the standard for issuance of show cause notices, etc. These are also issues which have been flagged by the FSLRC, and these have time and again been pointed in judicial proceedings pertaining to SEBI and similar bodies as well. So maybe while we're discussing with the working of IPS, we might maybe like to flag these issues as well, because in terms of long-term development of the entire insolvency ecosystem, these issues of segregation of different functions might also be important. So I think this is all from my side, but we'll be happy to see if there's any other contribution from anyone. And of course, Mr. Chaudhary, in case he
I think Mr. Kothari, that's a very important point about you made about separating these three functions. At IBBI, of course, there's a Chinese one, three functions. Also required of the IPs because all similar functions which are performed by IBBI. And can also give any other suggestions.
Can't hear you, sir.
That is,
Cannot hear
can
you,
also
sir.
take any, yeah. Better now, can you hear me? Can you hear me?
Quite faintly, sir. Maybe I think
I'll just get my mic, so we can just proceed. I'll just put on my mic. Yeah, I'm sorry, but I think my headphone is not working. So I think.
It's perfectly okay now, sir. We are able to hear you very clearly now.
Okay, fine. So idea was that if there are any other suggestions related to the governance, so that can also be put forward, and especially or whether we need to have some kind of. As of now, we have this provision for AFA. Whether the IPs who are there on the governing board should not be having an AFA. Any other suggestions in this regard? Or especially, we also said, I think somebody was talking about experience. So that can also be proposed. We did say about qualifications, but if you feel that experience should also be a criteria, that can also be proposed. We can also propose that some minimum experience, both for the shareholder directors and I would like to stress that different directors, there's still some measure of control are being nominated by IBBI, and wherever we feel that don't satisfy the criteria, we are calling for. But whether we would like to have this for shareholder directors also, that is to be debated, and also whether what kind of qualifications and experience we would like to have. And there was also a suggestion regarding that IBBI, having nominating independently. So, personally, I think we would not like to step in to that extent. We would still like to give some kind of leeway to the IPS in this regard. But you may still give your suggestions. We'll still examine that. If any of you feel that way, we can still consider that. But as of now, I think we would still not like to totally cut off the IPS from this process. I think we still want to have them a process. So that is why we would like the governing board to lay down this qualification experience. Only those directors who satisfy this criteria of qualification experience will be recommended by the IPA for nomination as a. And even for shareholder directors also we can consider. And also we need to debate whether we need to have the same criteria for both directors or shareholder directors, or you like to have separate criteria. I think that's all from my side.
Thanks for the guidance, sir. I think as regards the nomination of independent directors, solely by IBBI. Suggestions were made by Mr. Sanjay Gupta and Mr. Sanjeev Grover also. My view also is exactly reconciling with yours, sir, because the idea of an regulated self-regulation is that there is a limited intervention by IBBI. IBBI does not sort of become a direct intervention into the boards of governing boards of IPS, but that becomes a regular self-regulation. So I would favor the existing approach, which is nominations done by IPS, but IBBI still having a overarching power. In terms of the minimum experience and qualifications for shareholder directors, the point was very validly made. Dr. Binoy also made this point that if there is a minimum qualification for an IP itself, the fact that there is no minimum experience for the shareholder directors nominated by the IPS seems a little conflicting with that requirement. So maybe a minimum experience and minimum qualification could be laid for the shareholder directors as much as it has for independent directors. In terms of other points which might probably improvise on the working of the IPS, one of the points I'm just using the opportunity to flag a point which is surely not a part of today's agenda, is that to an extent there might be a duplicity in currently what we file with IPA and what we file with IBBA. There's in fact a substantial duplicity. So maybe that may be to an extent that is that's not probably not productive. So maybe that might be studied and might be maybe eliminated. Others, would you have any thoughts on that?
We can.
Yes, I second your views on this particular point, that duplicacy of data, because certain information which are being sought by IBBI also online, and the same type of set of information is being asked by the IPA. So in one case, if we fill it up, so it may be seen that whether we have to, it should be compensatory to each other. It should not be duplicating to each other. But even then in case, and if the same information, and some of the times, I think due to COVID, because of this COVID pandemic and other things, if any of the IP is maybe one reason or other, because of his own sickness or otherwise, not able to fill up provide any information to any one of the agency, like means principal regulator or to IPA, then in that case, I think the disciplinary action, etc., should be considerate enough, so that and understand that it should not be only because of non-compliance, intentional non-compliance. It may be due to certain reason, and in that case, the IPA should consider those things in case happens. That is the only thing.
So, you know, I also would like to quickly add to the point you mentioned. I'm Rajendra here. The submission of data and returns information to both IBBA and the ICSA IPA, yes, there have been several overlapping kind of situations, and maybe the technology itself was evolving. The digital platform was, introduced first. And then I have a fellow member from the Institute ICSA IPA, Ms. Mekhala is also part of the member of ICSA IPA. We have on many occasions found that we upload some information on the portals, but to our surprise, when you go back and see, whatever information you have uploaded is not there. Then you do the exercise once again. So similar to this, we felt a kind of a handicap on many occasions, and again we have to do. Of course, we have brought it to the notice of the authorities as well. So some practical difficulties have been happening in this area, and I'm sure as flagged by you, the regulators as well as the IBBA and the ICSA IPA, I think they have to be definitely taking note of such kind of difficulties faced by the IPs in the process. Thank you.
Right, sir. Any other point, anybody, or?
Yeah, I'd like to just say, Mr. Chaudhary specifically, the idea was three IPs was formed. Basically, what was the idea? The IPs should have an ease. It was like, envisages a concept of a telecom industry. Let's say whether you're a retail subscriber or Idea or, or a Bharti, which is the company. Because if you look at the services offered by any IP is similar. And nowadays, in case you want to opt out to another IP, it should be like a number portability. So idea, if you look at the Telecom Regulatory Authority of India, the concept of the TRAI is how it happens with the IPs or how they regulate the service providers. We are like the operators only, the three IPs. So if you look at among the three criteria of if you look at the company secretary or a cost accounting or a chartered accountancy, even the information seek and the data that has to be submitted, there is uniformity in some of the cases. One IP is seeking information on a quarterly basis, one is on monthly basis, one is asking for 5 more information. In case of liquidation, one IP is hardly seeking any information, another IP is asking too much of information. So technically, there should be uniformity. And what we brought the concept in CRC and TRI, basically we develop a concept of a mother warehouse. What happens for an IP? I have to disseminate with the information. Like a service provider, Bharti, he sends, there are different verticals in TRI. Like economic department, accounting department, there is a QoS, so many departments keep on asking a different kind of information, which is relevant for a different functions of IBBI or for an IPA. So what happened, there is a particular format, a uniform format, which is sent to the mother warehouse. And what happened within IBBI and within IPA, whatever information you want to seek, he can log in, that respective department can log in and pick up the information. So what happened for an IP? He is not overloaded with the summation of the similar data with a different point of view. So that worked very well with the Telecom Regulatory Authority of India also. So one, we were talking about this, the governance part, and other part, the manual, which whenever my governance manual was very different, which was not at all going along with the company secretary's manual. Because, what happened, I have a different board function, they have a different board function. So the idea is that, when all the three are regulated by one entity, some point of time, initially what happened when we started, nobody knew about IT, insolvency, bankruptcy board, there was no basis. But after that, so much of research has been done by IBBI, we have seen the UKs and so many other countries. After 3-4 years, a lot of standardization can be done today. Ideally, as I was saying, now what is happening, whichever IP is performing better, there should be option of a portability. Anytime you can, as an IP can port out to any other operator without any ease. So that should be the way. So normally do it, there is a lot of gaps still, if I go to another body, I find a different formats. So what happens, like I am running an entity, I've got 7 directors there. 2 are enrolled with the company secretaries, 2 are enrolled with the cost accountant, 2 are enrolled with the chartered accountants. But my company secretaries or my legal function, when they have to submit the quarterly information or whatever the information seek, all the formats are different, even the verticals are different. What happens finally is an IP. When I have to submit, I have to maintain a different set of formats. I have to see. Finally, I'm an IP. For me, it does not matter. So, but I have to maintain 3 different formats for my as an entity. Based on the IP, I have to submit the different information. So what is, and further we have another super regulator like IBBI. When they see same information, when I've submitted another, I have to submit it again. Like in liquidation, I've submitted some information, I have to submit it in 3 different verticals. So why don't we try to develop a concept, where we have a mother warehouse, where for an IP, I submitted whatever the relevant information is to that mother warehouse. And internally, IBBI can do, they can give the username and the password to different IPs. This information can be, utilized by IPs, and this is only for the IBBI. It should be the internal function, not for an IP to look into all these functions. So that will give you much more smoothing and much more ease. And the moment you look at XBRL, like in cost audit, we do XBRL format, even in TRI, we work out this format. So there will be a standardization. So the moment the data is being, submitted to IBBI, automatically through XBRL or any other software, through BI or business intelligence, or, even the IBBI can in no space of time, without effort, you'll be coming out with the value addition and the results. So that's a suggestion, because we have worked with all the regulators. So I think if this model can be worked upon and copied from others, so I think it will give a lot of ease to all the people. Because same thing, we have struggled a lot in the telecom industry. Luckily now there are, luckily or unfortunately, there are 3-4 operators. When I started the practice in telecom in 2004, there were 16 to 17 operators. Even the DOT and TRI was totally confused. The same set of information, it goes in the truck loaded to different departments, to different regulators. Same information. Possibly that software are already with the regulators like TRI, CRC and other operators. So I think for IPs, because he has to mainly for the resolution. The purpose is sometimes, I have 5 people just only for managing the data. That's my request to you. In case this burden are reduced on IPs, IBBI would have been better control, IP would have been better control. There'll be a lot of standardization also. So that was just a suggestion.
So I'll just respond briefly to Rajendran also. Aware that these CRP forms have been introduced from late last year. They are a comprehensive set of forms. And
Sir, you're not audible.
required.
I think, sir, you might need to come closer to the
One more. Let me see if
microphone. Yeah, I think the headphone was better. Yes, the headphone should be better, sir. No, sir, not at all.
Okay.
Or maybe
Okay.
sir,
Now?
yeah, much better.
Okay. So, we introduced these CRP forms, they are a comprehensive set of forms and it covers the entire gamut of information which is required in this CRP process. And the way these forms work is that the information is provided on the IBBI portal, but this access to the portal is provided to the IPS. So ultimate idea is that, this will be a comprehensive set of all the information which the IP needs to submit. And as you know, as of now, we are also submitting this relationship disclosures and cost disclosures on the website of the IPS. So we will, in course of time, we will extract this data from the CRP form itself. So that part will not be there. But as of now, what is happening, in fact, just before this meeting, we had another meeting on how to have this data from the CRP forms to the IPS. Because, the circular also provides that the IPS need to examine this data. So the access to the information has to be provided to the IPS. So we are working on this, that's how this data on the CRP forms can be, access to this information can be provided to the IPS. And if that happens, and hopefully that should happen fast, so then only the information would be required to be submitted on the CRP forms on the IBBI portal. So that is one part. Second part was, I think Sanjay ji mentioned about this portability. So that is something I think we are working on this. We have given a clear direction to the IPS that if a request has come for NOC, we cannot deny this request unless there is disciplinary action which is pending. And disciplinary action doesn't mean that you will initiate some process of some query or something on receipt of the NOC request. Disciplinary action is very clearly defined only if you have issued an SCN. That is disciplinary proceedings. So very clear directions have been given that if an NOC is request for NOC is received, then if disciplinary action is not pending, that is an SCN or other things as from the process starting from SCN, that has not been initiated, so NOC has to be provided. And I think there have been a few exceptions, but generally it has been happening. Was there any other issue which I had to react to?
I think that should be fine, sir. Anything else anyone has to add? So I think it's been a very useful interaction with everyone on a very important subject. And we are all extremely grateful for the very, very valuable suggestions received from all the stakeholders. Mr. Chakshu Gambhir or anyone from the IPA would like to take over? Thanks everyone. Extremely thankful for this opportunity. But anybody would like to take over to say the final few words?
Kothari sir, this is Nitin Satija. Thank you. Thank you very much. We thank all the participants for within such a short notice, they have made themselves available for this meeting.
So, Nitin, I would like to again thank Mr. Kothari. Earlier also he's taking this initiative, and he's done it in a beautiful way.
Yes,
he's master of this. He's compared this entire discussion in a beautiful way.
Yeah,
thank you, Mr. Kothari, and thank you all the participants. It doesn't affect you directly, but this is one area we need to contribute. It does affect us not directly maybe, but it is important for us.
Absolutely, we also agree with that view, sir. I think Mr. Vinod has handled very nicely.
Yeah, Nitinji.
Thank you, Nitin sir. We thank you, sir. We also thank all the other participants for having taken out time and engaged us in this very fruitful discussion. We have noted your suggestions, and I'm sure the solution forward will convince everybody that steps have been taken in that direction. Thank you very much.
Thanks everyone.
And Vinod Kothari sir, specifically, thanks to you. I mean, we were just thinking as to whom should we ask to moderate it, because we did not want to moderate it, being the IP itself. So although we are a participant here, we are listening to all the views that have been expressed, and we will surely take all the necessary actions and steps rather. And we thank you for having taken this discussion.
Thanks for the opportunity. Thank you very much. Thanks.
Thank you.
Thank you, sir. Thank you. Bye.